welcome to the final rounds of the Jessup competition. I would like to congratulate all the teams that participated this year. It was an amazing competition. It was very close. It was very exciting, and all of you should be very proud to be here. So please give yourselves a huge round of applause. I would like to introduce the teams who are competing in the final round this year. Pleading for the applicant from the University of Melbourne, we have, actually not pleading today, but on the team, is Peter Henley. Emily Hudson. Simon Moglia. And then pleading will be Nehal Butta. And Catherine Young. The coaches of the team are Ian Malkin and Sunya Pahuja. The respondent team, Universidad Catolica Andres Bello from Venezuela. Team members are Vicky Fulop, Renato Modernel, Thomas Norgard, and pleading today is Luisa Leprevanche and Patrizia Papiani. I'd like to just say a few words about our final bench. We're very honored to have the Honorable Judge Stephen Schwebel with us today. Judge Stephen Schwebel has been a member of the International Court of Justice since January 15, 1981. He was the Vice President from 1994 to 1997 and the President of the Court from 1997 to the year 2000. Prior to joining the Court, Judge Schwebel was the Assistant Legal Advisor for the Department of State 1961 to 1966, Special Assistant to the Assistant Secretary of State for the International Organization of Affairs, 1966 to 1967. We also have with us Mr. Gavin Griffith. He served as Solicitor General of Australia from 1984 to 1997. While Solicitor General of Australia, Mr. Griffith was agent and counsel for Australia in the International Court of Justice in both the Nauru case and the East Timor, Portugal versus Australia cases, and also pleaded for Australia in the Nuclear Weapons Advisory Opinion. He now practices as counsel in Australia and London, specializing in international, constitutional, and commercial law, and as an international arbitrator. Finally, we have Ms. Barbara Mishkin. Ms. Mishkin is an attorney with Hogan & Hartson here in Washington, D.C. She works with issues relating to the federal regulation of biomedical research. Prior to joining Hogan & Hartson, Ms. Mishkin served as Deputy Director of the President's Commission for the Study of Ethical Problems in Medicine and Biomedical and Behavioral Research. So good luck to both teams. And we begin.
The distinguished panel consists of President Schwebel and the Honorable Judges Mishkin and Griffith.
Please be seated.
The case before the court is a matter of Caracas versus the Republic of Sahaba. The applicant and respondent team each allocate 45 minutes to present the respective pleading.
I call on counsel for the applicant to address the court.
Mr. President, Your Excellencies, my name is Katie Young and I appear on behalf of the State of Caracas with my co-agent, Nehal Butta. I will be speaking for 20 minutes, my co-agent will be speaking for 21 minutes, and we reserve 4 minutes for rebuttal. Your Excellencies, In a time when individuals in developing countries are increasingly the subjects of biomedical research, this court is being presented with the opportunity to affirm the fundamental and basic rights of the human person. Cenever is permitting the experimentation on the bodies of the most vulnerable members of its society without their proper consent. Karaka makes 4 submissions. First, that the court has jurisdiction because the 2 reservations invoked by Cenever do not apply and because Karaka has standing to bring the claim. Secondly, that Cenever has breached international law in arbitrarily detaining George Smith. Thirdly, that Karakan Law 1006 complies with customary international law governing informed consent in medical experimentation. And fourthly, that the remedies Karaka is seeking are within the competence of this court to grant. I shall be making the first 2 submissions, and my co-agent shall deal with the second 2 submissions. Turning first then to jurisdiction. Jurisdiction is brought before the court under Article 36(2) of the Statute of the International Court of Justice. Cenever relies on the principle of reciprocity to invoke the 2 reservations attached to Karaka's declaration. While Karaka does not contest this right of reciprocity, as it is espoused in Article 36(2) of the Statute of the Court, it does contest the application of those 2 reservations to the present case. Turning first to the domestic jurisdiction reservation, this reservation excludes the court's jurisdiction in matters essentially within the domestic jurisdiction of a state as determined by that state. Cenever has made a determination that this dispute is within its essentially domestic jurisdiction. However, Cenever is unable to make this determination in good faith. It is submitted by Karaka. Karaka submits that the implication of good faith to the interpretation of the reservation is consistent with 2 fundamental principles before the court. The first is the principle of good faith as a fundamental principle that when a state is conferred a discretion, it must exercise that discretion in good faith. The principle of good faith was affirmed by this court in the Nicaragua decision in its application to an acceptance of the compulsory jurisdiction of the court under Article 36(2).
Counsel, may I ask you a question? In the jurisprudence of the International Court of Justice, has the court ever held that a self-judging reservation is subject to the test of good faith?
Your Excellency, the court has never held that the test of good faith should be implied. However, we submit that the implication of good faith is consistent with these principles and that only with the principle of good faith can it be ensured that the self-judging reservation is not an illusory obligation but is in fact a genuine one. This would remove the problem that the court might find that the reservation is in fact invalid as an illusory obligation. We submit, therefore...
Oh, sorry, Ms. Young, could I interrupt there? It might be put that if this was so clear, why didn't Karatza, when it was drafting this reservation itself, include a phrase to say to be exercised in good faith to make the matter clear? You're, in effect, calling upon, perhaps on one view, the shortcomings of your own reservation, to use it to assault a respondent which seeks to rely upon your very words.
We submit that it is not necessary for Karaka to attach the words that the determination be made in good faith, because it is a fundamental principle that where there is a discretion, that discretion is exercised in good faith, and that this implication is also consistent with Article 36(6) of the Statute of the Court, which allows the court the power to determine its own jurisdiction, and not a state coming before the court to determine that jurisdiction.
Counsel, you'll recall the case between Bulgaria and the United States, in which Bulgaria invoked the Conley Amendment against the United States. Does that support your interpretation of good faith?
Mr. President, it does in the case that the United States in oral pleadings did refer to the principle of good faith, but that case was ultimately settled, and that to look to the jurisprudence of the court, we can only look to the cases of certain Norwegian loans and the Interhandel case, where the court did consider the reservation and in fact applied the reservation in the case of the Norwegian loans.
Now you mentioned certain Norwegian loans. Was there any relevant difference in the condition of reciprocity in that case and in the clauses in this case?
Yes, there was, Your Excellency, in that the reservation itself did attach the words that it was to be exercised on condition of reciprocity.
Is there any consequence of that difference?
We submit that there is not, because of the Anglo-Iranian Oil Company decision. That is, that the principle of reciprocity is attached to all reservations under Article 36(2 as it refers to the same obligation between states.
Whether expressed or not?
Whether expressed or not, that's correct. It is therefore our contention that Seneva's determination is justiciable by this court, and this court needs to look to whether the determination was in fact manifestly unreasonable or the discretion was exercised in a capricious way. We submit that it was, in this case, by two fundamental acts by Seneva. First, the act of signing the Convention on Human Rights and Biomedicine, which is the treaty bringing the specific human rights relating to informed consent into the realm of international law. In the interpretation of peace treaties case, this court recognised that when treaty obligations were relevant to a matter, that matter could no longer properly be considered as within the reserved domain of a state. It is therefore Caracas' submission that Seneva has acknowledged the relevance of human rights standards to medical experimentation. Secondly, the statements by the Prime Minister and the Minister of Foreign Affairs in paragraphs 28 and 32 of the compromise specifically recognise the relevance of international law to the dispute in their allegations that Caracas has in fact breached international human rights law. These statements are binding on Seneva because of the principles of consistency and trust and confidence in the statements made by countries, particularly in the negotiation of a dispute, as was held in the status of Eastern Greenland case.
Ms. Young, could I interrupt you there? Is there any room for the scope of considering reasonableness when deciding whether or not there's good faith? For example, in this case, could it be said that Seneva is having regard to the immediate health requirements of its population, therefore it might have a rather stronger view than what other might be the case as to what is appropriate reasonably, and does that impact at all on the characterisation of good faith in your submission?
We submit that the test of reasonableness is an important one in assessing the good faith or otherwise of Seneva's determination, but that because of the two statements made and because of the signature of the Convention on Human Rights and in fact the participation in its drafting, those factors outweigh the factors such as Seneva's relying on the recent context of this dispute.
Thank you.
If there are no further questions regarding the domestic jurisdiction reservation, I will turn then to the multilateral treaty reservation, which it is submitted has no application in the present case. The multilateral treaty reservation requires that in a dispute arising under a multilateral treaty, all parties to the treaties affected be present before the court. In the jurisprudence of this court in the Nicaragua case, the requirement is that a party have a materially and practically affected interest. We submit that there are no such parties in this dispute. Firstly, because of the allegation that Nemen perhaps could be such a party. The fact that Nemen's link to this dispute is only in the interests it may or may not have in George Smith, who is a citizen of Nemen. We are asking the court to adjudicate on the detention of George Smith, and it is our submission that that is contrary to customary international law. It is therefore clear that there is no dispute regarding George Smith that arises under a multilateral treaty reservations because Caracas' submission is reliant only on customary international law. If there are no further questions regarding the multilateral treaty reservation, I would turn then to the third objection to jurisdiction, and that is that Nemen may be considered an indispensable third party. It is submitted that the doctrine that an indispensable third party, if absent, may preclude the court from adjudicating the dispute is one reserved for exceptional cases when this court is asked to adjudicate on the conduct of a third state without that state's consent, as were the words of Judge Azevedo in the Corfu Channel case and applied in the exceptional cases of Monetary Gold and of East Timor, when in those cases Albania and Indonesia's conduct respectively were to be adjudicated by the court felt that it could not adjudicate that conduct and those interests. Yemen's interest in this proceeding is more of a corollary to the interest of Bangladesh in the trial of Pakistani prisoners of war case, where India submitted that Bangladesh was an indispensable third party because rights of Bangladeshi nationals had been infringed. The court held that this was no objection to jurisdiction. If there are no further questions regarding jurisdiction, I would turn then to the admissibility of Karaka's claim.
Counsel, could I ask you one question about that? Do your submissions here deal at all with the question of whether or not Karaka can be a claimant with respect to a non-citizen, or is that something you'll deal with separately?
That is falling under the admissibility of the claim. Would you like me to turn to that now?
No, not at all.
That is the second part of admissibility. The first is that Karaka has standing on behalf of the corporation Megaceutical Seneva, or alternatively the shareholders in Megaceutical Seneva. Dealing first with the corporation, it was recognised in dicta in the Barcelona traction case that the presumption that a corporation would hold the nationality of its state of incorporation can be displaced, particularly when that incorporation has only been brought about by local laws and when the close and permanent connection of that corporation is with a different country. In this case, the close and permanent connection is with the state of Karaka, as the control is exercised in that state, as well as the management decisions and, in fact, finance. It is therefore submitted that Megaceutical Seneva is properly to be treated as a Karakan national, and Karaka can therefore exercise diplomatic protection on behalf of it. Your Excellencies, I will then deal with the question of George Smith. Karaka asserts the right to exercise diplomatic protection on behalf of George Smith on two alternative bases. First, as Karaka's agent, and secondly, on behalf of the international community as a whole because of breaches of obligations owed erga omnes. Dealing first with the agency of George Smith is employed by the Karakan Government Medical Product Regulation Agency. In his role, he must advise the Karakan government and in fact represent Karaka in Seneva, a matter to which Seneva has specifically consented. It is therefore submitted that Karaka has the right to exercise diplomatic protection on behalf of him, firstly, because the United Nations reparations case tells us that nationality is not the only basis for which a state or organisation can exercise diplomatic protection, and secondly, because of the corollary of the fact that George Smith can in fact incur the responsibility of the state of Karaka under the doctrine of state responsibility and under Article 8 of the draft articles on state responsibility. It is submitted.
Can I ask you a question about this? It just seems to me that it might be put that the Nottenbaum case suggests that you have to be a citizen to get to first base on these arguments, but what's your view about that?
Again, we would submit that there are exceptions to the nationality rule, exceptions such as when an individual is acting in the army or on a ship's crew of a state. Those exceptions preceded the Nottenbaum decision. We submit that scholars such as Fitzmaurice and Brownlee have supported the view that when an individual is acting in the service of the state, that state may exercise diplomatic protection on behalf of that individual, and that the International Law Commission, in its recent preliminary report on the rules of the exercise of diplomatic protection, have noted that it may be time, or the time has passed, to reconsider the classic notions and the classic rules governing diplomatic protection and the requirement that a state must have the nationality of that, the citizen must have the nationality of the state.
Are you inviting us to take up the invitation of the ILC?
Yes, Your Excellency, in order to confirm the existence of that rule at international law and to apply it. The alternative basis on which Karaka seeks to have standing on behalf of George Smith is because of breaches owed to the international community, breaches of human rights which every member of the international community has a legal interest in protecting. It is submitted that Barcelona Traction did consider the rule the right of a state to protect an infringement of an obligation owed erga omnes, and that the list that the court made out in the Barcelona Traction was not an exhaustive one, and therefore could be included to include other basic human rights than those that were explicitly stated.
Counsel, when you speak of exercising diplomatic protection by the route of erga omnes obligations, are you distinguishing that from diplomatic protection and saying that it's quite different from diplomatic protection?
Yes, Mr. President. It is quite a different and alternative basis for standing. However, again, this basis is confirmed by the International Law Commission's preliminary report, which recognises that international law is now more concerned with the rights of individuals rather than purely the interests of states.
Well, Ms. Young, what sort of rights do you mean to apply in this proposition? For example, it might be suggested that in the case of Elian, that any state might take proceedings to say he should be reunited with his father. Is this a principle which you advocate?
We would submit that the principle is based on an erga omnes obligation, that is, when a human right has been breached, that has been recognised as being owed to the international community as a whole. And we submit that in the specific case of Caracas' claim, the prohibition on arbitrary detention is such a right, or the right to be free from arbitrary arrest, and that Caracas can indeed seek to protect that right. For example, the United States restatement has, in section 702, confirmed that every state may protect the right or an individual who has been subject, or individuals subject to prolonged arbitrary detention. While the United States requires that the abuse of that right be widespread, we would submit that it is applicable in the present case, although we don't have a lot of facts about Ceneva's policy in this matter, that Ceneva has indeed threatened the personnel of Megaceutical Ceneva in the very same way as George Smith, and threatened to detain them.
Do you have a problem here of exhaustion of local remedies?
We submit that we do not, because there is no available remedies, or no reasonably available remedies open to either George Smith or to Megaceutical Ceneva, and that the burden of proof therefore shifts to the respondents to show that there are, as per the Finnish shipowners' arbitration and the statements by Judge Lauterpacht in the Interhandel case. It is not a reasonable possibility that George Smith may be freed, as we have given no facts of any means that he has in challenging his detention. He has been given no bill of particulars. He has only been told that he has interfered with public health measures, and that is not a charge or a formal charge that would suggest that his detention was not arbitrary. If I could move then to that detention, it is Caracas' submission that it does breach the customary international law, that the individual does have a right to be free from arbitrary arrest, and that this prohibition gains its status in custom not only by its articulation in numerous multilateral human rights treaties, but also as supported by this court in the Tehran hostages case and in the recent Baragwitsa case, as an example, before the International Criminal Tribunal for Rwanda. We submit again that George Smith has been given no grounds for his arrest and has been detained now for over 7 months. Ceneva is unable to rely on the derogability of this right for 2 reasons. Firstly, because the declaration of a state of public emergency occurred in fact 1 month after George Smith's arrest, and that this declaration must be made out because of the Gabčíková case. Secondly, that the derogation must be strictly necessary in all the circumstances, and we can see no causal link of the detention of George Smith and any alleviation of the public health crisis which Ceneva is now facing. If there are no further questions, I see my time is about to expire. That concludes the first submission for Caracas.
Thank you, counsel. I call upon your co-counsel.
Mr. President, Your Excellencies, Karakan Health Law 1006 is a valid protection of the right of all persons to give their free consent before being subjected to scientific experimentation. In the merits phase of this proceedings, Karaka makes two submissions. Firstly, that Health Law 1006 is a valid exercise of extraterritorial jurisdiction to prescribe, which in no way derogates Senevan sovereignty. And secondly, that the remedies sought by Karaka in this case are within the competence of the court and should be awarded. Turning then to our first submission, Your Excellencies, Health Law 1006, at Regulation 1006R and also in Section 6, subsection 4, provides that Karakan nationals who participate in medical experimentation overseas must comply with certain standards set out in Health Law 1006. This is extraterritorial in its application, Your Excellencies, insofar as it prescribes conduct for nationals taking part in activities overseas. However, in our submission, Your Excellencies, states have a wide discretion to legislate extraterritorially, provided they do not breach another prohibitive rule of international law. So much is clear from the statement in the Lotus case, which was recently reaffirmed by this court in the advisory opinion on nuclear weapons case. In our submission, Your Excellencies, we have exercised this extraterritorial, we have exercised our discretion to legislate extraterritorially validly and within our limits, because Health Law 1006 codifies and is consistent with customary international law governing informed consent.
Excuse me, Counsel, I'm puzzled by your reference to the nuclear weapons case. Could you elaborate for a second on that?
Certainly, Your Excellency. In the nuclear weapons case, the majority opinion considered the question as to whether or not states have absolute freedom of conduct, subject only to prohibitive rules, and there was reliance upon the Lotus case. The issue was, can states use nuclear weapons in the absence of a specific injunction or apparent prohibition in international law? Ultimately, it was held, Your Excellencies, that the use of nuclear weapons may be illegal. But the relevance for this case is that the Lotus rule concerning the relative freedom of states subject only to a prohibitive norm was reaffirmed in our interpretation of the case. Now, Your Excellencies, in our submission, the context of the Lotus case was, of course, concerning an extraterritorial application of legislation by Turkey in respect of a French sailor, and is thus analogous to the situation here. We are submitting that Law 1006 cannot be considered to violate Senevan sovereignty because it, firstly, only prescribes conduct to our nationals, and that is a well-accepted basis for the prescription of extraterritorial conduct. And secondly, that the standards that we prescribe are standards which codify international law governing the conduct of vaccine trials, such as those which are about to go ahead in Senevan. And Your Excellencies...
Well, Counsel, you've said that, but how do you support that proposition?
Your Excellency, our submission is that in international law, involuntary experimentation is cruel, inhuman, or degrading treatment. That is, the prohibition on cruel, inhuman, or degrading treatment, which is a well-recognised norm of customary international law, appearing in all multilateral human rights treaties and recently affirmed as custom by the International Criminal Tribunal for the former Yugoslavia in the Frunzia case, specifically contemplates involuntary experimentation as a sort of conduct which is prohibited. This much is clear from the Travaux Préparatoires to Article 7 of the International Covenant on Civil and Political Rights, and also the Travaux to the Universal Declaration on Human Rights.
Well, Counsel, isn't that a little bit frozen? I mean, for example, we have now the Convention on Human Rights and Biomedicine. Of course, that's not in force, but does that, in your submission, visit at all upon the principles here?
It certainly does, Your Excellency, and that indeed would have been the next reference I'm going to make. The Convention on Human Rights and Biomedicine, which, to my recollection, entered into force on the 6th of December in 1999, expresses the requirement of informed consent in medical experimentation. And as Karaka and Senevan are both signatories, and moreover were both participants in the drafting of this convention, Your Excellencies, it's interesting to look at the Travaux, which state at paragraph 34 that in the view of the drafting parties, the convention codifies the well-accepted customary rule concerning informed consent.
But didn't the events here occur before the coming into force of the convention?
Yes, Your Excellency, it seems that the events did. However, in our submission, the application or the particular dicta that I referred you to in the travaux indicate that all parties considered it to be a customary law rule that informed consent must be protected.
Was it relevant whether the parties to this matter were signatories at the time of the events?
Your Excellency, it does matter because in our submission, Seneca also has an obligation not to frustrate the objects and purposes of that treaty, and if they were to go ahead with the trials as currently contemplated, they would do so.
What's your authority for that submission?
Your Excellency, that's based upon Article 18 of the Vienna Convention of the Law of Treaties, which requires that states do not act in a manner which frustrates the object and purpose. And in our submission under Article 1 of the Convention on Human Rights and Biomedicine, which is intended to guarantee fundamental freedoms, and in light of the statements in the travaux which I've referred you to, the protection of informed consent is one such fundamental freedom.
Counsel, can you think of an alternative approach you might have taken to this impasse other than simply withdrawing the trials?
Your Excellency, in our submission, we are entitled to ensure that our nationals do not engage in human rights violations overseas and to stop them from doing so. It is not our place in our submission to redraft the protocol. That is a matter for Megaceutical Corporation and for the Senevan government. And the Senevan government in its diplomatic statements thus far has seemed quite insistent that the trial go ahead in its current form. So our submission is, Your Excellency, not that we're opposed to vaccine trials per se, but that the vaccine trials be consistent with international law, and if our nationals are to participate, those nationals not be involved in human rights violations.
But could you have insisted that they go back to the review board and negotiate a different approach to conducting the trial?
Your Excellency, there's nothing that we have done which would preclude that option. We are quite happy for Seneca and Megaceutical Corporation to revise the guidelines, but none of them have chosen to do so.
This is somewhat relevant to the exhaustion of administrative remedies, it seems to me. And I didn't read anything with respect to any attempts to negotiate some sort of change in the protocol and the consent form.
Yes, Your Excellency, and indeed we don't have any information on that matter. Our submission is, though, that it is open to Seneca to do so, and if they do object to the process under our administrative law, then it is open to them to enter our jurisdiction and do so. But it is not our responsibility in our submission to do so. Turning then, Your Excellencies, to this very question, what was wrong with these trials, and why did we feel compelled to ask our nationals to stop participating under the law? Your Excellencies, in our submission, if we accept that in international law there is a customary law requirement that individuals give their consent before they are subjected to medical experimentation, the question becomes, what is the meaning of consent in customary international law? Your Excellencies, when states parties to the ICCPR drafted Article 7, they expressly left the question of consent open in its meaning, and we're not suggesting that there is a single rigid definition of consent. We accept that concept of consent may be flexible. However, if the concept is to have any meaning at all, it, in our submission, must have three requirements, and these three requirements are reiterated in the municipal laws of many nations around the world which protect informed consent, and also in the intergovernmental policy and guidelines promulgated by organisations such as the World Health Organization and the International Conference on the Harmonisation of Drug Laws. And these three requirements have remained constant for 50 years since Nuremberg. That is, that there be sufficient information as to the risks and benefits of the trial, and that they be conveyed in a way which ensures understanding. Second, that the persons to be used in the trial are appropriate and have the capacity to give consent. And thirdly, that there is an absence of duress. And Your Excellencies, our submission is, this is the content of consent in international law, and this content has not been satisfied by the protocol which was to be used in Seneca, which is found at paragraph 20 of the compromis, and also that the subjects of the trial were inappropriate. So if we could turn then, Your Excellencies, to the question of the subjects of the trial. Seneca is proposing, as we are told in paragraph 8 of the compromis, to test this vaccine on only vulnerable persons, as far as we can tell, including which are prisoners, children, and outer island villages, and women in maternal health clinics. Your Excellencies, in particular, we raise the issue of prisoners and children. It is almost universally accepted that prisoners, because of their almost permanent situational duress, should not be subjected to medical experimentation without very specific safeguards. This much was clear from the report of the International Penal Law Association in 1982, and also from the findings of the General Assembly in the body of principles concerning all persons under detention.
Counsel, can I just interrupt you for a second? How would you characterise what you proposed here? Is it a trial or is it a treatment?
Your Excellency, in our submission is very clearly a trial. We not only rely on the facts in the compromis, but Your Excellency, there are two reasons why this is a trial. First of all, this vaccine has never been tested before. We are told that it is a new variant, 0.78 kappa, which a previous variant of which has been tested in a phase 1 trial on only 30 subjects. Before a drug is finalised for approval, Your Excellencies, it usually goes through at least 3, if not 4 stages of testing. This would only be a phase 2 or a phase 3 test, and indeed it can only be characterised as a trial. It's a very promising agent, certainly.
And how does that answer support your propositions?
I'm not quite sure I follow you.
I don't want to be obscure, but is it a strength to your argument that you characterise it as a trial rather than a treatment?
Yes, Your Excellency, it is, in that what we are speaking about, Your Excellency, is international law norms governing consent to experimentation. If this is treatment, it's not experimentation in our submission. But if it is experimentation, then requirements of consent must be satisfied. Because the question is, what are these people agreeing to? An unknown risk, an unknown quantity, and hence consent as to risks and benefits, which may or may not be therapeutic, must be obtained.
But in the initial trials of any new drug, wouldn't those who consent to try it be consenting by definition to something unknown?
Yes and no, Your Excellency, in that in the guidelines to which we referred, a drug will approach medical or human testing only after a certain degree of animal testing, early phase 1 human testing, and then phase 2 testing. So yes, it is unknown, Your Excellency, but it is tested at a stage at which it is believed the risk has already been minimised to a certain degree. And in our submission, the risks in this case, because it is an untested variant altogether, are unforeseeable. And even if it is presumed to be at least as safe as the previous drug, the risk is still quite high, unacceptably high. 7% developed debilitating asthma, a serious complication. Yet in the view of the Royal College of Physicians in the United Kingdom, a 1 in 100,000 chance of a serious complication is a minimal risk. So, Your Excellencies, if I turn though then to the subjects of the trial, which I was addressing previously. In our submission, prisoners should not be used in this trial because there is inadequate protection of their consent. There's a general presumption against the use of prisoners because of their situational coercion, but even in guidelines such as the Council of International Organisations and Medical Science Guidelines and the Council of Europe Guidelines, to which the State of Senegal has referred, which permit experimentation on prisoners, there's 2 conditions: that the risk be no greater than minimal, and that special measures are taken to ensure the proper consent of these people whose consent may otherwise be vitiated. And in this case, those factors are not present.
Can I take you back to something you said a few minutes ago? Because I think I heard you say that Senegal was proposing to use prisoners and children and so forth. But isn't Megaceutical a Moroccan corporation?
Yes, Your Excellency.
And wasn't the protocol drafted by them?
Yes, Your Excellency. The protocol found in paragraph 20 was drafted by Megaceutical Corporation. The selection of trial subjects, as we are told, I believe, in paragraph 8 of the compromis, was by the Senegal Ministry of Health.
I thought it was by the faculty member who, the principal investigator at the university, and Megaceutical, who proposed to do it on those populations for reasons of cost and convenience and ready availability of subjects.
Respectfully, Your Excellency, I believe that they confirmed the assessment of the Senegal Ministry of Health, which deemed those populations to be most at risk. The question, however, Your Excellency, doesn't change for us because these are our nationals, Megasuku Corporation and Dr. Yukawa Lopez. And in accordance with our obligations under Article 7 of the ICCPR, articulated by the Human Rights Committee in General Comment 20, we are entitled to ensure that our nationals don't participate in a trial which is defective or going to violate human rights. So the fact that our nationals participated is, in our view, a reason why we can regulate them.
You can regulate them, certainly, but I guess I'm trying to get at the question of whether regulation doesn't sometimes entail going back to them and saying pick some other subjects rather than just you can't go to this other country and conduct your research.
Again, Your Excellency, our submission is that nothing is stopping these people from revising the protocol. The Karakan Medical Ethics Review Board of the university has stated that the current trial, as proposed, is unacceptable, not that no trial is possible. Secondly, Your Excellencies, on the question of whether or not the protocol itself is sufficient. In our submission, it is not. It is a requirement of guidelines such as COMS at Guideline 2, and indeed it is the practice of developing states confronting pandemics such as AIDS who use vulnerable populations, and it is recognised that they may use vulnerable populations in some circumstances, to ensure very careful requirements of consent. For example, in Thailand, when trialing a HIV vaccine on commercial sex workers and army personnel who are vulnerable, there was a careful process of ensuring comprehension of what a trial is, what a vaccine is, what the risks are. There was an opportunity to reconsider. There was ensurance that non-literate populations would have the information presented to them in an adequate way, such as through visual diagrams. Your Excellencies, in the developing world, this is standard practice, even in those who are confronting pandemic situations with the HIV virus. Indeed, 100% of all the developing states who are listed on the WHO vaccine trial registry comply with the high requirements, or the rather stringent observations, of COMS and good clinical practice. And in our submission, this is the standard which should be applied to the conduct of these trials, and it is comparable to the standards applied by the developing world in confronting pandemics. Thus, Your Excellencies, our conclusion is that the informed consent protocol in its present form is a read-out and sign, or a cursory read and sign process, which did not present sufficient opportunity for the subjects, and in light of their vulnerability, to adequately consent to the trial, and as such, these trials would have been illegal in international law had they proceeded.
Can I ask you one more question, and that is, if the consent process, not just the form, but the process, had been in complete agreement with the standards as you understand them, would you have permitted it to go forward, or do you have other concerns about the trial?
Your Excellency, in accordance with the ruling of the Karakan Capital University Medical Ethics Board and the views of George Smith, if these standards had been satisfied, I could see no reason why Health Law 1006 would stop it.
You have no concern about the placebo controls?
Your Excellency, we have no concern about the use of placebo per se in the absence of best available treatment. In our view, that is accepted in practice, that you can use a placebo if no other treatment is available. What we do have a concern about is, under the informed consent protocol, there was no mention of the use of placebo. And as such, that was misleading the participants who are told that they will be injected with an experimental vaccine. In our submission, that goes to the quality of consent, because they are effectively not consenting to the possibility that they won't get an experimental vaccine at all.
If the phase 1 trials had strongly suggested that this treatment, this vaccine that's being tried, might be a useful therapy, would you then find no problem with placebo controls?
Your Excellency, if the assumption is that everyone be given the vaccine and no placebo be used, in our view that would cause a difficulty in respect of the scientific validity of the trials in the absence of a control group who is not receiving the vaccine. This is nevertheless ultimately an experiment, Your Excellency. It is not yet treatment.
And historical controls?
Historical controls, Your Excellency?
Right.
I'm not sure I understand.
If you know that the likelihood is becoming infected and having symptoms within 3 years, death within 3 years, and X% of your subjects or your patients or your citizens dying by a certain point, if you can bring that down by, say, 50% and prevent so many from getting the disease and another large portion from dying, then comparing your experimental subjects results with your results from history, can you not demonstrate an improvement?
Perhaps, Your Excellency, I must defer to Your Excellency's scientific knowledge on that matter. I'm afraid it's not an area in which
If
I have
one
expertise.
could, would your government accept that, or would you still insist on the placebo control?
No, we wouldn't insist on the use of placebos, Your Excellency. We have no specific objection to them.
All right.
Your Excellency, my time is rapidly approaching. If I could quickly summarise the question of remedies. It has been our submission, Your Excellencies, that
Counsel, before you do that, and I'd be inclined to suggest you have another minute to finish.
Certainly, Your
I'm not exactly clear in your submissions as to whether you've dealt with the obligations of Caracas or whether your submissions run to submit that there's any obligations on Senator which are relevant.
You mean, Your Excellency, in relation to...
The question of dealing with trials and the obligations to comply with international standards.
Yes, Your Excellency. It has been... I see my time is up, Your Excellency.
You may have another minute to reply, Counsel.
Thank you, Your Excellency. Your Excellency, our submission has been that there are two sets of obligations here. First of all, specific obligations on Caracas pursuant to the ICCPR concerning our nationals and our right to regulate them to ensure we do not violate rights under those conventions. But secondly, an obligation which applies to both states pursuant to customary international law, namely that medical experimentation not be conducted without consent. So, Your Excellency, our submission is that that is customary international law which applies to both Senator and Caracas, and that we are entitled to ensure that our nationals don't participate in that sort of activity, and that indeed it is incumbent upon Senator to ensure that those trials are conducted in accordance with international law.
Thank you.
Your Excellency, in the 30 seconds remaining, I would like to refer Your Excellencies to our written memorials on the question of remedies. Briefly, we ask for a return of the €2 million paid by Megaceutical Corporation, the release of Mr. Smith, and a declaration that Caracas Health Law 1006 is a valid exercise of our extraterritorial jurisdiction.
I'll just ask you one question. I hope that the President will give you an extension to answer it, is that it's really been a change of heart by Caracas as to whether it wanted to go on with the trials, having regard to what it sees international obligations. Is that a solid basis to claim your money back?
Respectfully, Your Excellency, our submission is that there is a doctrine of unjust enrichment in international law, as accepted by the Lena arbitration, and that what has occurred here is that there has been a dispute between the two parties as to the meaning of international law. Caracas has not changed its mind. Health Law 1006 always existed, and in our submission it has always been in compliance with international law. What the change in circumstances which has occurred is the dispute as to the meaning of these obligations between Senator and Caracas, which has meant that the agreement between Megaceutical Corporation and Senator cannot be performed.
Well, I don't want to have the last word, but I mean, there might be a principle of unjust impoverishment as well involved.
Perhaps, Your Excellency, but in our submission, in the application of the law, we are entitled to the return of the money.
Thank you, Counsel.
Thank you, Your Excellency.
Thank you, Counsel. That concludes the opening argument for the applicant. I now call on counsel for the respondent.
May it please this honorable court. Good afternoon, Mr. President Schwebel, Your Excellency Griffith, Your Excellency Mishkin. My name is Patricia Papayani Hernandez, and I'm an agent on behalf of the Republic of Sinheva. My co-agent is Luisa Teresa Lepervanche, and Citizens Counsel is Renato Modernel. I will be addressing this court for a period of 20 minutes regarding the following two issues. First, I shall address the matter of jurisdiction, and that Caracas lacks standing to exercise diplomatic protection on behalf of Megaceutical Sinheva and George Smith. Second, that the extraterritorial application of Health Law number 1006 is illegal under international law. My co-agent will be addressing this court for a period of 22 minutes regarding that Caracas must remove all obstacles to the conduct of the MHVD vaccine trials. And in the alternative that the vaccine trials are not carried on, this court should award monetary damages. The Republic of Sinheva will be saving 3 minutes for Sir rebuttal. If it pleases this court, I shall begin with my first submission. Your Excellencies, the facts as submitted in the compromis pose a grave dilemma to the Republic of Senheva. On the one hand, we have valid means to object to this court's jurisdiction, and on the other hand, we need this court to compel the state of Curaçao to remove all obstacles to the conduct of the MHVD vaccine trials. The Republic of Senheva has posed both on a balance, and due to the seriousness of the MHVD problem, the Republic of Senheva has understood that it is the best interest of the Senhevan people that the Republic of Senheva withdraws its objection to jurisdiction. However, Your Excellencies, Senheva does object to Curaçao's claim of standing on behalf of Megaceutical Senheva and George Smith. Your Excellencies, with regards to the contention of our esteemed colleagues on behalf of this applicant state, they have submitted that close and permanent connection is a sufficient basis for the exercise of diplomatic protection on behalf of corporate entities. Your Excellencies, the Republic of Senheva recognized that this court in the Barcelona traction case did refer to the existence of the effective connection principle, but Your Excellencies, it also determined that no genuine test of effective connection had found general acceptance in the international community. And Your Excellencies, not only is Megaceutical Senheva incorporated under Senhevan laws, it has also genuine connection with the Republic of Senheva. And since there is no genuine test of genuine connection, we submit that the connections between Megaceutical Senheva and Senheva are sufficient for this court to determine that it is a national of the Republic of Senheva, because all of the operations of Megaceutical Senheva are to be found in Senheva. Its headquarters, production facilities, and 51% of the share interest is in the hands of Senhevas. We recognize that the control is in the hands of Megaceutical Corporation, but Your Excellencies, if we place these on a balance, we have the state of Curaçao with control of Megaceutical Senheva. On the other hand, we have Megaceutical Senheva, which is incorporated under the Senhevan laws, and we have all of the rest of the connections with the Republic of Senheva. And therefore, Your Excellencies, we submit that it is a Senhevan nationals and that Curaçao cannot bring a claim on its behalf.
Counsel, could it be relevant as to where this particular vaccine was manufactured?
Your Excellency, it was manufactured in collaboration with Megaceutical Corporation and Megaceutical Senheva.
But can you tell me where it was developed?
Your Excellency, there is no clear indication in the compromis where it was developed, but since Megaceutical Corporation is the parent company, it is easy for us to assume that given the technology and given the resources of Megaceutical Corporation, the vaccine was developed in Curaçao and Megaceutical Corporation.
And so wouldn't it be reasonable for the country to regulate a drug within its particular boundaries that was developed there and presumably at some point would be marketed there? And that would then be internal rather than extraterritorial, wouldn't it?
Yes, Your Excellency, we are aware that Curaçao has a right to regulate its vaccine, but Your Excellencies, when there are two concurrent jurisdictions, this court should recognize, as Professor Bowett established, that which is the jurisdiction that should prevail. And Your Excellencies, Professor Bowett established that territorial jurisdiction was a fundamental principle of jurisdiction. And in order to establish which jurisdictional principle should prevail, a test should be made. And among these principles would be the non-intervention principle, Your Excellencies. And we submit that the MHVD vaccine trials are a matter of national importance to Senheva, a matter of public health, matters of public order. And Your Excellencies, it should...
Can I just stop you there, Counsel? At the moment, would you say it's a trial or a treatment, this vaccine?
Your Excellency, this is a therapeutic vaccine. It is for the prevention of MHVD and for the cure of MHVD.
Does it yet exist? I mean, is it being trialed or is it a treatment?
There was, it was tried in phase one studies on 30 MHV positive volunteers in Senheva, Your Excellency.
Because, I mean, could it be suggested if it's merely being trialled, it doesn't particularly matter whether it's trialled in your country or in some other part of the world?
Indeed, Your Excellency, I believe it would not be relevant that it would be tried in any part of the world, but the fact is that it was tried in Senheva, and that Senheva relied on the fact that Megaceutical Senheva was undertaking the vaccine trials in Senheva, Your Excellency.
Thank you.
But you don't, I'm sorry, but you don't know, do you, what the long-term effects of this will be? It was tried just a year or so ago, right, in 30 subjects?
Could Your Excellency repeat the question?
Yes. If it was tried only in 1998 or 99 and only in 30 subjects, have you any basis for assuming that it will necessarily be a useful treatment without very bad side effects when it is viewed over, say, 5 or 6 years on 1,000 subjects?
We do not know, Your Excellency. It is established in the compromis that 28 of the 30 subjects had substantial improvement. But, Your Excellency, my co-agent will be dealing with the vaccine trials in detail.
Counsel, you said a few moments ago that the respondent withdraws the objections to jurisdiction that it earlier had brought forward. But I take it from the tenor of your argument that the respondent maintained its objection to the admissibility of the claims of the applicant. Now, if the objections to admissibility were to be sustained, what would remain before this court?
Your Excellency, the matter that would remain would be the conduct of Curaca, whether Curaca's conduct under international law is legal or it is illegal, and if the MHVD vaccine trials should proceed and this court should order the removal of the obstacles, Your Excellencies. And this is exactly the essential matter that we want this court to decide, and that is why we have withdrawn our objections, because it is in the best interest of the Senhaven people that this court regards this matter. Your Excellencies, with regards to our esteemed colleagues from the applicant state other submission with regards to George Smith. Your Excellencies, the nationality principle is the basic principle for the exercise of diplomatic protection. There are indeed 3 exceptions, which are erga omnes obligations, the United Nations right with respect to its agents, and the rights of diplomats and consuls. But, Your Excellencies, none of these exceptions apply. With regards to the submission of the applicant that George Smith is in the service of the state. Your Excellencies, I refer you to the same wording of the compromis. It established that George Smith is a private independent consultant. Such a status does not grant George Smith any diplomatic immunity or any special status. Your Excellencies, as it is established in the compromis, Megaceutical Corporation, the Curacan Medical Product Regulation Agency gives an independent consultant to all Curacan pharmaceutical companies engaged in activity abroad. This means, Your Excellencies, that the state of Curaca has an enormous number of people subjected in activity overseas, because, Your Excellencies, Curaca has a great biomedical research and is one of the most advanced countries in these proceedings. And therefore, Your Excellencies, we submit that George Smith is a mere independent consultant and has no such a status as a diplomat or a consul. With regards to the applicant's submission with regards to the United Nations reparations case, Your Excellencies, first of all, the United Nations has agents. It does not have nationals. And this established the ruling because of 3 reasons. First, because of the unique rights and duties of the United Nations. Second, because of the political task of the United Nations, which is the maintenance of international peace and security. And third, because the obligation of Israel was due to the United Nations. And the same United Nations Charter has given the United Nations such particular characteristics, and therefore I do not believe Curaçao can claim that it has unique rights and duties, that George Smith was engaged in Senheva for the maintenance of international peace and security, and that Senheva's obligation is due to Curaçao. Therefore, Your Excellency, the United Nations reparations case is not applicable in the present case. With regards to the applicant's alternative argument, which was the erga omnes obligation, Your Excellencies, it is true the Barcelona Traction recognized fundamental human rights. But, Your Excellencies, fundamental human rights are those who allow no derogation. And, Your Excellencies, the prohibition against prolonged arbitrary detention is a derogable right. And, moreover, in the Vienna Convention on the Law of Treaties, Article 53, it has been established that peremptory norms of international law are those who allow no derogation. And generally, Your Excellencies, jus cogens norms are those who entail erga omnes obligations. And Your Excellencies, the prohibition against prolonged arbitrary detention does not entail an erga omnes obligation. And Your Excellencies, the state of Curaçao has relied on the Restatement Third of the United States of America on foreign relations. And Your Excellencies, this is not a sufficient basis to claim that the prohibition against prolonged arbitrary detention is an erga omnes obligation. And Your Excellency, we submit that this court has been very restricted, conferring the category of jus cogens norm to particular human rights. And therefore, Your Excellency...
Counsel, can I test you on that? What if you had a particular ethnic group and the entire members of the group in a state were kept in prolonged arbitrary detention? Could that constitute such a matter? Would you concede, or you're saying that it's not capable of being characterised because as a topic it is capable of being derogated from?
Your Excellencies, if it was discrimination, yes indeed, non-discrimination, non-racial discriminations is a jus cogens norm. But if these people, if this minority was held in detention because of lawful actions, this would not constitute a discrimination and therefore would be lawful and would not entail any erga omnes obligation, Your Excellency. Your Excellencies, with regards to the contention of the applicant on the non-exhaustion of local remedies, that there are no remedies to be exhausted in Senheva, Your Excellencies. Your Excellencies, such an assumption cannot be made, for as the world stands today, every state has a judiciary system, at least one tribunal. And Your Excellencies, the habeas corpus procedure is always available to people, even under states of emergency.
Well, Counsel, is there an issue of onus here? Who is to establish exhaustion of local remedies or non-exhaustion?
I beg your pardon, Your Excellency, could you repeat the
Who
question?
has the onus to establish exhaustion or non-exhaustion of local remedies, in your submission?
The Republic of Senheva has the burden of proof with regards to the existence of local remedies. But if the state of Curaçao claims that these remedies are futile, they should prove to this honorable tribunal that they are futile, and there must be overwhelming evidence, Your Excellency.
Is there any evidence here on the existence of local remedies?
Your Excellencies, the Republic of Senheva has a prime minister, a ministry of health, has a president, has a minister of foreign relations. Your Excellencies, it is evidence that the Republic of Senheva can deal with a complex structure, with a complex public system. And, Your Excellencies, I may dare to presume that they do indeed have a judiciary system. Your Excellencies...
Well, I understand, Counsel, you presume that, but should we assume it?
Your Excellencies, I am very sorry if I would presume, and since we are in a court of law, we are not permitted to presume. But, Your Excellency, these facts all linked together can constitute circumstantial evidence, Your Excellencies. And as stated in the Corfu Channel case, states can rely on circumstantial evidence if there are no other means to determine the state of the state in that
But, Counsel,
particular...
there might be other means. You might have told us.
Excuse me, Your Excellency?
You might have told us in the compromise.
Yes, Your Excellency, indeed. But since the compromis is silent, we can avail ourselves only of what is written in the compromis. And, Your Excellencies, as we have submitted in the international community nowadays, all states have a judiciary system, or at least one tribunal. Your Excellencies, we have submitted the issues of standing with regards to Megaceuticals Ceneva and George Smith, and our position is that Curaca does not have standing with regards of either of them. We will now submit, Your Excellencies, that the extraterritorial application of Health Number 1006 is indeed illegal. Your Excellencies, we have submitted that the vaccine trials are a matter of public health in Ceneva, a matter of essential priority in Ceneva, and therefore Ceneva should be entitled as a corollary of state sovereignty to regulate these matters. Indeed, we do admit that the nationality principle has been recognized as basis for the prescription of laws, and that Maria Yucaba Lopez is a physician that has Curacan nationality. But, Your Excellencies, we have presented with a concurrent jurisdiction, and which jurisdiction should prevail, and we submit that it should be the Republic of Ceneva, and that Curaca does not have a right to impose its standards upon Ceneva. And furthermore, Your Excellencies, that the application of Health Law Number 1006 has been unreasonable, and my co-agent will submit to this court indeed how unreasonable such application has been. And therefore, Your Excellencies, we submit that the extraterritorial extension of Health Number 1006 is not justified under international law, given the circumstances of the MHVD problem. Therefore, Your Excellencies, we might submit to this court that a declaratory judgment be given, and indeed declaratory judgment have been awarded by this court, as in the Corfu Channel case. And, Your Excellencies, our final submission is that Ceneva's sovereignty is in question, and that Curaca, by interfering in matters which are essentially within domestic jurisdiction, has violated Ceneva's sovereignty, and therefore that this declaratory judgment be awarded to Ceneva.
If Ceneva objected to the conduct of this trial on basis of its own law, would you view that as your inherent right to control what is done in your country, or would you view that as an extraterritorial imposition on Curaca?
Your Excellencies, in principle, Ceneva has a right to regulate the activities within its territory. There's no indication if there's any law that indeed regulates these activities, but we do have a Ministry of Health which oversees all ethical standards and practices in Ceneva.
And what is it about what Curaca is doing in telling its own faculty within its boundaries that a drug developed within its boundaries to be marketed from its boundaries may not go forward? What is extraterritorial about that?
Your Excellency, the application, the extraterritoriality, we do not object, Your Excellencies. We object to the fact because there is a permissive regime with respect to extraterritorial extension of jurisdiction. But, Your Excellencies, we do object to the form in which this extraterritorial extension has been made, and it has been made in an unreasonable manner, Your Excellencies, because there were other means on behalf of the state of Curaca to protect the activities of its nationals involved in biomedical research in Ceneva. Other means other than the halting of the MHVD vaccine trial. As my co-agent shall prove to this honorable court, this has been unreasonable. Your Excellencies, I see that my time has run out. Thank you very much.
Thank you, counsel. I call now upon your co-counsel, please.
May it please this honorable court. Good afternoon, Your Excellencies. My name is Luisa Teresa Lepervante, and I am an agent on behalf of the Republic of Ceneva. I will be addressing this court for the following 22 minutes regarding the removal, Curaca's obligation to remove the obstacles to the execution of the MHVD vaccine trials in Ceneva, or that in the alternative, this court should award Ceneva compensation for damages. Your Excellencies, our first submission is based in two issues. First, in the issue that the obstacles are not justified under international law. And secondly, in Curaca's obligations to help solve the MHVD crisis. Your Excellencies, the first of these two reasons, which is Curaca, that the obstacles are unjustified under international law, is based on two facts. First, that the ethical standards that regulate medical experimentation on human beings that have been proposed by the applicant state are not actually binding upon Geneva. And secondly, that the halting of the MHVD vaccine trials is unreasonable, is in breach of the principle of reasonableness.
Counsel, could I just
Yes,
pause
Your
there?
Excellency.
Is there another issue? Is there any obligation on Geneva to comply with international standards for trials?
Your Excellency, yes. Geneva is bound under the Convention on Human Rights and Biomedicine to comply with its object and purpose, since it has signed said convention. And it is also bound not to violate the prohibition against medical experimentation without a free consent. However, Your Excellencies, it is our submission that it is not specifically bound under the technicalities which the applicant state has submitted. Your Excellencies,
I'm sorry, what do you
Yes.
mean? That you could develop another protocol?
I beg your pardon.
Is your suggestion that Geneva could develop another protocol quite apart from that which has been proposed?
No, Your Excellency, we're submitting that Curaca should have ordered the redesigning of the protocol. If Curaca had ordered the redesigning of the protocol, instead of exactly saying that the trial should be stopped, then that Geneva would definitely have agreed to proceed, Your Excellencies, because the issue at hand is the execution of the trials. Your Excellencies, we will begin by submitting that the only binding ethical standard regarding medical experimentation has been complied with, and that, Your Excellencies, is the Hippocratic Oath. Your Excellencies, the Hippocratic Oath mandates that that physicians must always follow that system, that regime of conduct, which will be for the benefit of the patient. Your Excellencies, that is the principle of thou shalt do no harm. It is our submission that it is in the best interest of all Geneva test subjects to be vaccinated with the MHVD variant developed by Maria Yukawa Lopez, the leading expert. And why, Your Excellencies? Because 20%, at least 20%, of Geneva's population is already infected with MHVD. MHVD is a disease that attacks the human liver, disrupts the digestive system, and nearly invariably leads to death within 3 years. And no known cure, Your Excellencies, has been found. However, Megaceutical Corporation, in collaboration with Megaceuticals Geneva and Maria Yukawa Lopez, seems to have developed a vaccine that would work both as a prevention and as a cure. Your Excellency,
Can you explore that
Yes.
a little bit for me? What do you base that understanding on? That it works both for prevention and for treatment?
Your Excellency, the clarifications of the compromise express that in this particular case, experimental vaccine shall be one that might prevent, ameliorate, or treat a disease. And therefore, it is our submission that this vaccine would have been both a prevention and a cure. Your Excellency, I know that this is not the usual meaning of a vaccine. However, in the clarification, that is what was stipulated.
That may be the meaning of vaccine, but I guess I'm asking you on what factual basis you have a reasonable expectation that this particular product will work in those two ways.
Well, Your Excellency, a toxicity test has been conducted using 30 MHV positive persons, and 28 showed substantial improvement. Therefore, it is our submission that the vaccine would work as a cure. As for the prevention side, Your Excellencies, paragraph 15 of the compromise states that the population chosen to serve as test subjects were the populations believed to be at greatest risk. And therefore, we can presume that they were chosen, since the chosen, although the esteemed colleagues of the applicant have submitted that the selection was done by the Ministry of Health. That particular paragraph states that the Ministry of Health agreed to permit the trials to be conducted in said population, and therefore it is our submission that it was not the Ministry of Health but Maria Yukawa Lopez who chose the population. And if she was the one who chose the population, then we can very well presume that she did it on the grounds that this vaccine would also prevent, Your Excellency.
You don't think that's simply a hope on somebody's part or a justification for using vulnerable populations to test something that perhaps they would not have tested in their home country?
No, Your Excellency, I don't believe that is the case, because Maria Yukawa Lopez is the leading expert on MHVD. It is not the presumption of any person, Your Excellency. It is the presumption of a highly qualified doctor, and furthermore, Your Excellencies, even if these tests are conducted in Senheva, it is not conducted in Senheva because it could not have been conducted in Curaca, but because Megaceutical Corporation chose to do so on the grounds of the prevalence of the disease on Senheva, Your Excellency.
My understanding from the compromis that it chose to do so for reasons of cost and convenience, and availability.
Yes, Your Excellency, and the prevalence of the disease in Senheva, Your Excellency. That is also stated in the compromis, I believe it is paragraph 7. Your Excellencies, we would submit that particular prohibition against harm is the only relevant ethical standard binding. And Your Excellencies, we submit that binding as customary international law. As for the signature of the Convention on Human Rights and Biomedicine, Your Excellencies, Senheva must not commit acts which would defeat the object and purpose of said convention under Article 18 of the Vienna Convention on the Law of Treaties. Your Excellencies, it is said object and purpose is established under Article 1 of the Convention as the obligations of state parties to protect the dignity and identity of all human persons and to guarantee everyone, without discrimination, respect for the right to integrity and other human rights and fundamental freedoms with respect to the application of biology and medicine. Your Excellencies, it is our submission that that is precisely what is being done. We would like to point out, Your Excellencies, that the European Court in Human Rights in the D versus the United Kingdom case ruled that not providing a person with treatment for an HIV infection constituted a violation of the prohibition of Article 3 of the European Convention for the Protection of Human Rights and Fundamental Freedoms. And Article 3 prohibits torture or cruel, inhuman, or degrading treatment. And therefore, Your Excellencies, it is presumable that what the court meant was that not providing HIV treatment to that particular person constituted a violation of his right to integrity.
Counsel, are you sliding here from submitting that we're dealing with trials to submitting that we're dealing with the treatment?
I beg your pardon, Your
Are you sliding between submitting that we're dealing with a trial to submitting, by the references you just made, to a case of treatment?
Your Excellency, I apologize if I did not make myself clear. We admit that this is a trial. This is definitely a trial, Your Excellencies, as is expressed by the consent form. However, we submit that it is a therapeutic trial, that these people would benefit directly from the application of this vaccine, Your Excellencies.
But the fact that it's a trial means we don't know, doesn't it?
No, Your Excellency. However, yes, Your Excellency, it means that there is a possibility that it might or it might not work. But we do have evidence, Your Excellencies, that this vaccine produced substantial improvement, that a variant of this vaccine produced substantial improvement. And it is our submission, Your Excellencies, that these test subjects, that Senhevan people should be given the opportunity to choose between acquiring an MHVD and dying of it, which is the logical consequence of not being vaccinated, considering that this disease spreads through 4 separate vectors, including air, Your Excellencies, or the possibility of being immunized by the vaccine or cured by the vaccine, Your Excellencies. Test subjects must be provided the right to decide what they want to do, Your Excellencies.
Is there a third possibility?
Yes, I beg your pardon. Is there a third possibility?
Is there any other possibility that comes to mind?
That this vaccine is tried, Your Excellency, in other population, and once it is shown that it works, these people can buy it. But Your Excellencies, this is a developing country.
No, I had in mind the possibility that the vaccine might prove to be very toxic in the long run.
Your Excellency, we submit that pharmaceutical companies around the world, when developing a vaccine, a variant of a vaccine, if a toxicity test has been conducted with another variant, what they usually do, Your Excellencies, is that they take out the toxic element. So it is highly probable that this vaccine would be the same or even better, or regarding the risks, Your Excellencies, that the risks will be the same or lesser. That is our submission, Your Excellencies. And a 7% risk or a 6.6% risk of acquiring debilitating asthma is not, Your Excellencies, an unjustifiable risk. I would like to bring forward another precedent of another treatment, Your Excellencies. However, if it applies to treatment, we submit that it also applies to experimentation. It is another case of the United Kingdom, Your Excellencies, and it was the X versus United Kingdom case, where the United Kingdom government decided to develop certain programs for vaccination of children with certain vaccines. And Your Excellencies, as a result of those tests, there was a 15% risk that these children might develop side effects. And some of the side effects, Your Excellencies, included death. The ruling of the International Tribunal was that that risk was a proportionate risk. And Your Excellencies, it is our submission that this is even a more serious case, Your Excellencies, because we have a disease that is killing, that we have a disease that has already infected 600,000 Sanhaven nationals, Your Excellencies, and that within the next 3 years, these persons are surely going to die, Your Excellencies. I would like to proceed, Your Excellencies, with the obligations that Curaca has with regard to with the international obligations of Curaca to cooperate with the MHVD problem, Your Excellencies. These obligations are found in two separate sources. The first one is the UN Charter, Your Excellencies. Paragraph 3 of the Compromise expresses that both parties to this dispute are also members of the United Nations, and therefore, Your Excellencies, they are bound to comply with the United Nations Charter. Article 55 and 56 of the and under Article 55 and 56 of the UN Charter, Curaca is bound to cooperate in helping solve international health problems. Your Excellencies,
Cooperate with whom, Council?
With the United Nations, Your Excellency. However, we submit that this would apply to not obstaculizing Sanhaven's efforts to control its MHVD pandemic, especially, Your Excellencies, since Sanhaven has declared a state of public health emergency. And I will address that issue if Your Excellencies, I will proceed with the obligation and then I will address the issue of the state of emergency.
Council, can I just interrupt
Yes.
there? I just have a problem about the logic of your argument. If you establish that Curaca is in breach of its obligations under international law with respect to what are the appropriate protocols for this trial, is there any need to go any further to this next argument? If you already win, if you win on the previous proposition,
Yes.
do you need to advance to this argument?
If you rule on the previous...
If you win on that point, do you
No, Your
have to-
Excellency.
Now, if you lose on the first point, where does this proposition get you?
The next one, Your Excellency? It is a different source, Your Excellency.
Yes, but if you've lost on the point that the proposed protocol is in breach of international obligations...
Oh, you were referring to the protocol. If this court decides that the protocol was in breach of international law, or even if it decides that if this court decides that the protocol was indeed in breach of international law, we will proceed with the argument, Your Excellencies, that Curaca's actions were unreasonable. And I will address that issue if Your Excellency so wishes.
Even if it wasn't in breach of international law, you wish to establish a separate argument, do you, that there's an obligation with respect to this broader obligation that overcomes that? Do you follow?
Could you
I don't mean
rephrase?
to be obscure, but I'm just not sure where you get, if you fail on the argument that Curaca is in breach of its obligations with respect to international law by reason of these protocols. If you win on that, well then you're in a strong position perhaps. If you lose on that, is it possible to maintain that there's a separate obligation in international law nonetheless to proceed with the trials?
No, Your Excellency. But we will submit that if this court decides that the research protocol were indeed in breach of international law, then Curaca acted in an unreasonable way, Your Excellencies. And that itself would constitute a breach of international law. And I will address that issue, Your Excellencies. we would like to submit that this honorable tribunal has previously recognized the principle of reasonableness. We would like to submit that in the Gapchikos Nagimaros project case, a similar situation was presented to this court. Hungary decided that going ahead with the project of the construction of the system of locks would be too risky for environmental reasons. But Your Excellencies, this court stated that even if the continuance of the project was indeed risky, then Hungary had means available to it other than the halting of the project. And that, Your Excellencies, is precisely our submission. If Curaca indeed, if this court indeed finds out that the vaccine trials as proposed in the research protocol were in breach of international law, then we submit that Curaca had other means, Your Excellencies, to redress its concerns regarding said trials, and other means that would not cause Ceneva a great detriment, Your Excellencies, such as this measure that was taken, that was the ordering of halting the project, Your Excellencies. Since if that indeed, if this court decided to rule that the research protocol was in breach of international law, and that it was in breach of international law, not with respect to the obligations contracted by Curaca, but with respect to the obligations that are also binding upon Ceneva, then that would be our submission, Your Excellency. I see that my time is running up. May I be permitted to address the issues of damages?
Please.
Your Excellencies, it is our alternative argument that if this court does not order Curaca to remove the obstacles to the execution of the MHVD vaccine trials, then this court should award Ceneva compensation for damages suffered. But, Your Excellencies, we want to make it clear that what we're seeking in the first place is that this court should order Curaca to remove the obstacles and therefore award Ceneva an injunctive relief, Your Excellencies. And that has been previously done by this court. An example, Your Excellencies, was the Temple of Preaviar case, when this honorable court ordered Thailand to give the statues that had been in the temple back to Cambodia, Your Excellencies. We haven't submitted that would be the remedy that we are seeking in the first place. We now submit that if this court does not remove the obstacles, then this court should award Ceneva compensation for future damages, Your Excellencies.
What could the future damages be, Counsel?
Your Excellencies, it would be we would have to treat these MHVD victims that would not have had to be treated if the vaccine trials had been carried out, Your Excellencies.
But what if the trial was unsuccessful, that vaccine didn't work?
Your Excellencies, it is if the trials didn't work, then if the trials hadn't worked, Your Excellency, then Ceneva would not need to have its rights redressed. But it is our primary submission that the trials would have worked, and that since Curaca posed obstacles...
You don't know that, do you? And suppose the trials, instead of working as they worked on these 30 people that
Yes.
you are relying so heavily on, suppose instead they produced blindness after 5 years. Then you would have thousands of people. You would have much greater problem than had the trials not been conducted at all. So I'm at a loss to understand how you would compute your measure of damages based on presumptions and, excuse me, something will work when there's no way to know.
Your Excellency, in 5 years, as your submission was, in 5 years, if these people were not vaccinated with MHVD, they will not be blind, but dead. And that is our primary submission. But even if it is true that there is a possibility that this vaccine might not work, the evidence that we have so far is that the vaccine will work. But we are not stating that the damages have to be awarded, and I beg your pardon if I did not make myself clear, for the actual result, but for the difference that it is going to cost Ceneva to develop the technology to execute the trials on its own. If Megasurgical Corporation had collaborated, then the trials incurred in expenses if Megaceutical Corporation does not collaborate because of obstacles posed by Curaca, then Ceneiva would have to develop the technology in order to achieve the result of the vaccine, Your Excellencies. And that difference is what we are asking this court to award the compensation for. And in order for the percentage that should be awarded, we submit that as it was done in the Corfu Channel case, Your Excellencies, as it was done in the Corfu Channel case, this court could appoint a panel of experts in order for them to determine with which amount Curaca must reimburse to Ceneiva, Your Excellencies.
Counsel, would you also be asking in order that the vaccine be made available for trials which you conducted? Where would you get your vaccine otherwise?
Beg your pardon?
Where would you get the vaccine unless we also order that the vaccine be made available? Is that part of your claim?
Your Excellency, it is not clear in the compromise whether the vaccine is in the hands of Megaceutical Ceneiva or in the hands of Megaceutical Corporation. If the vaccine if the vaccine is in the hands of Megaceutical Ceneiva, we can very well presume that they will, we can presume that the vaccine, the technology could be developed. Megaceutical Ceneiva as a Ceneiva national. I see that my time is up.
Please finish
I'd
your
like to
point,
hear the
Counsel.
answer.
Please finish your counsel.
Your Excellencies, Megaceutical Ceneiva is a Ceneiva national, and therefore it could collaborate with the Republic of Ceneiva to develop the MHVD vaccine against the disease. So it is our submission that what we are seeking, if the vaccine is not in the hands of Megaceutical Ceneiva, then we seek that the vaccine be available. But what we are actually seeking is for damages for the technology, Your Excellencies. Thank you very much.
With the President's consent, do you have any submissions to make as to whether, if you're otherwise unsuccessful, you should be ordered to pay back the $2 million?
I was going to ask.
Your Excellency, if this court awards damages for the, first of all, we would like to submit that that if Megaceutical Corporation seeks that Ceneiva handles the 2 million euros back, it must exhaust the local remedies within Ceneiva. However, if this court, if Megaceutical Corporation, which was the one that made the payment, seeks to have the 2 million euros back, Your Excellencies, then it should go to the courts within Ceneiva, Your Excellencies. But if this court decides to award damages, and that those damages include the 2 million euros, then Ceneiva will accept the judgment, Your Excellencies. Was that your question, Your Excellency?
Well, I was wondering whether you want to submit that whatever happens, you shouldn't have to pay the $2 million back.
Oh. You're not asking a question, right?
No, I'm asking whether...
What was the $2 million for, in your understanding? What was supposed to be done with that?
Well, Your Excellency, as a foreign company came to the Republic of Ceneiva and sought permission to conduct trials. In order for that permission, it must have sought licenses, Your Excellencies, and would submit that if there is a possibility, we can only speculate, because the compromise is not clear as to what was the reason of the euros. We can submit that it was a contract, that it was for the licenses. Your Excellencies, there is no clear evidence as to what the 2 million euros were for. However, we submit that since the trials were not conducted, Ceneiva can retain those 2 million euros in order to try to redress the situation, Your Excellencies.
I was just trying to find out if some of that money or all of it had been used for the purposes for which it was intended initially. But we don't know, I guess, is really your answer.
Thank you so much, Counsel. I now call upon the applicant for its rebuttal.
Your Excellencies, the State of Caraca wishes to make 3 points in rebuttal. The first concerns whether we have violated the duty of non-intervention. The second concerns whether Ceneiva is indeed acting in the best interest of its population as it claims. And the third concerns the question of remedies and the damages that they seek. Turning then to the first submission, Your Excellencies, the State of Ceneiva has claimed that in enacting extraterritorial legislation which codifies informed consent, in our view, we have violated the duty of non-intervention. Your Excellencies, the statement as to what amounts to a prohibited intervention is found in paragraph 205 of the Nicaragua judgment in this court. A prohibited intervention occurs where one state attempts to regulate or otherwise interfere in a subject matter in which a second state, by virtue of the principle of state sovereignty, may freely decide. Your Excellencies, in our submission, we have not violated this test on the basis of our primary submission, which is international law governs the conduct of medical experimentation with a requirement of consent. If international customary law governs the area, Your Excellency, it follows that it is not an area in respect of which all states, by virtue of state sovereignty, may freely decide. Your Excellencies, the state of St. Harbour has submitted also that Law 1006 is an intervention in their jurisdiction by virtue of unreasonableness, yet they have not sought to clarify what factors are to be applied in this test of unreasonableness, if it indeed is to be applied, as it is a private international law doctrine. That test was first articulated in the Timberlane case, a US Municipal Court decision, but has been taken up by the European Union in the Woodpulp case and also in the EC directive. Those factors set out in the American Restatement and also in the Timberlane case include assessing the links between what is regulated and the area in which it is regulated and the nation in which it is regulated, and also whether or not the regulation seeks to uphold a rule of international law of importance to the legal system. In our submission, Your Excellency, this regulation is reasonable as an exercise of concurrent jurisdiction because it only regulates our own nationals, which we are entitled to do, and secondly, it regulates them in accordance with international human rights law. And thus, in our submission, we have acted reasonably in our application of this legislation. Turning then, Your Excellencies, to the content of informed consent and whether or not Seneca is entitled to claim that it is acting in the best interests of its population. Your Excellencies, there has been much confusion as to whether or not they are talking about experimentation or treatment, and we are also somewhat puzzled. In our submission, Your Excellencies, international law requires consent for experimentation, and this is experimentation. They have conceded as much on page 11 of their compromis at paragraph 50, where the pleading as to best interests does not appear. If they are claiming to act in the best interests of their citizens, Your Excellencies, they are bound by their obligations under the Convention on the Rights of the Child, for example, to ensure that children are not exposed to exploitation or cruel, inhuman or degrading treatment. And as we have submitted, involuntary experimentation is cruel, inhuman or degrading treatment. Your Excellencies, the second submission, or rather, to just briefly conclude the previous one, they have referred to examples of D in the United Kingdom that again involved a situation of treatment, Your Excellencies, and the deprivation of treatment. This is not a treatment and could not be considered so. Yet a comparable case is available on experimentation, namely X in Denmark, where it was stated by the European Commission that involuntary experimentation is cruel, inhuman and degrading treatment. The final submission, Your Excellencies, concerns damages. In our submission, the statement of law that should be applied is that found in the Chorhub factory case. A speculative and contingent claim cannot give rise to damages. It is speculative to claim that a variant of a vaccine trial still in the early stages of development will have full therapeutic efficacy. It is furthermore contingent as to how many people get MHVD, which is substantially within the hands of the Senate and government, as we are told in paragraph 6 of the compromis. The most effective way of stopping the prevention of the treatment of this disease or the spread of this disease is environmental measures. Your Excellencies, that concludes the rebuttal of Karaka.
Thank you, Counsel. I call upon Counsel for the respondent for its rebuttal.
Your Excellencies, the Republic of St. Helena will now exercise its right to serve rebuttal. Your Excellencies, we're not submitting that the extraterritorial application of Health Law number 1006 is in violation of the principle of non-intervention, but in violation of the principle of reasonableness, Your Excellencies. And it is clear that the test that should be conducted is were there other means to regulate nationals abroad that would not cause a detrimental effect on the state where those nationals were located? And the clear answer, Your Excellencies, is yes. They could have redrafted the protocol. Regarding the second submission, Your Excellencies, that there is no consent and that would breach the inhuman treatment prohibition, Your Excellencies, we would like to make two submissions. First, that there is indeed a consent, but that if that particular consent does not comply with formalities that have not acquired customary international law status, it doesn't mean that there is no consent. Your Excellencies, but that particular but that the particular formalities that have not been complied with are not essential to the consent being valid or not. And Your Excellencies, as to the reference to cruel, inhuman, or degraded treatment, I would like to submit the following. Your Excellencies, that the Article 7 of the ICCPR does prohibit medical experimentation on human beings without a free consent as a particular form of inhuman treatment. But it does so, Your Excellencies, and one has to analyze why it was drafted. Your Excellencies, it was drafted after Second World War, where indeed inhuman treatment experimentations were conducted. Your Excellencies, we have all heard stories about Mengele and the twins. We have all heard stories about the vacuum pressure experiments or about the cold water experiments. Your Excellencies, this is definitely not the case. And to affirm that Senhiva's actions to provide its population with the right to health and therefore the right to life are in violation of the prohibition against inhuman treatment. It's absolutely inaccurate, Your Excellencies. I would like to leave Your Excellencies with a final thought, and that is, Your Excellencies, even if international guidelines regarding medical experimentation on human beings are good, they are an optional good because they are not binding upon Senhiva. But Your Excellencies, respect, and they must be balanced, Your Excellencies, with respect for the right to life. And that is not optional for Senhiva or any other state, Your Excellencies, but mandatory. Thank you very much.
Thank you, Counsel. The court will now rise to deliberate.
The court is now adjourned.
Don't forget to turn it off.
Please be seated. The tribunal warmly congratulates both teams on an absolutely first-rate exchange of arguments, both in substance and style, and not least on the fine English displayed by both teams. On balance, and not without difficulty, we find the winning team is that of the applicant. The tribunal will now proceed to the presentation of the cups. We should like first to award a cup to the best oralist. This has been a particularly difficult decision because the oralists were so fine, but again, on balance, on very narrow, quivering balance, we find Mr. Nehal Bhutta the best. Then we should like to award a cup to the most excellent runner-up team. Congratulations. 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 Thank you. Congratulations. Very much, And finally, it's our pleasure to present the winning team with 2 cups, only one of which is small enough to be handed over. Thank you, sir. Congratulations. Congratulations. Congratulations.
I'd like everyone to thank our final bench. They were exceptional today.
Thank you, sir.
We'd just like to say thank you to everyone, and we'll plan to see you tonight at the gala.